deep inside, there's a huge part of me that's gone.
The horror is once you get out, trying to get back what you'd lost.
When you're on that side of the bars and there's no way, there's no hope, there's no crack, you give up.
Took away a big portion of my life, took away my life with my children.
I mean, what happened to the word investigation?
Helpless, fear, anger, and revenge, and wanting people to be held accountable for what had happened to me.
And why? Why did you do it? What possessed you to play God?
I knew my life was over right there.
Having my family taken away, everything taken away from me.
I had my life stolen away for 25.5 years for a crime I didn't commit. You can't get that time back.
Hi, I'm Kelly Fanson.
And I'm Kelly Lozo.
And this is Real Life Wrongs, where we dive into the stories, the crimes, and the hard times of the complicated world of wrongful convictions.
Episode 11, Bad Lawyering. Guest, Jason Gilbert.
Oshawa, Ontario, Canada, October 9th, 1993. It's morning, and pretty much like any other day, you wake up and feed your 2.5-year-old son, Kenneth, some breakfast. You spend the morning at home playing with him, watching cartoons, fussing around the apartment. Later, you both take a nap. It's around 4 p.m. when you wake up to hear Kenneth calling out for you. He's calling Mommy, but his voice seems muffled. You go to him and find him tangled in the sheets. They're so twisted, they're actually hard to untangle, and you start to panic. He's still calling your name, but his voice gets more faint. You reassure him as you try to roll him out of the sheets, but you're considering scissors to cut the sheets. But that seems dangerous, so you continue working the tangle. Time is standing still, but you're moving as fast as you can to release him. You get him free, but he's turned pale and doesn't seem to be breathing. You carry him with you to the phone and call 911. The ambulance arrives within minutes, but Kenneth has now stopped breathing. You panic and beg the paramedics to make him breathe. They try everything. Unable to revive him, they rush him to the local hospital, with you in the back beside him. When you arrive, an emergency room physician attends to Kenneth, and about 10 minutes later, his heart begins to beat again. He's placed on a ventilator. A feeling of relief washes through your entire being. Next, the doctor explains to you that they're transferring Kenneth to the Sick Kids Hospital in Toronto for extended care. This time, Kenneth rides alone, as there's no room for you in the ambulance. But you don't have any way of getting there on your own. Next thing you know, the police offer you a ride. Of course, you accept. You get in the police car, but instead of taking you to the hospital, they take you to the station. You don't know what's happening. You're desperate to get to your son. Inside the station, they bombard you with questions. You try to answer their questions, but everything is a blur and your mind keeps yelling at you to get to the hospital. Eventually, their questions relent, and your husband arrives. Together, you are rushed to Sick Kids Hospital. You are reeling. That was a confusing ordeal, but you're heading to Kenneth, which is where you're supposed to be. When you get to Sick Kids, you're told he's in a deep coma with minimal brain function. Their diagnosis is severe brain injury caused by lack of oxygen. You actually don't know what this means. The doctor tries to explain to you. You're also urged to donate Kenneth's organs because it would save other children. You agree to donate. If you can save others from what you're going through, then yes. 3 days later, Kenneth is pronounced brain dead and taken off of life support. It's been the longest 3 days imaginable. You speak with the doctor who's been attending to Kenneth, and you explain he suffered from asthma and epileptic seizures. You're starting to wonder if this may have had something to do with his death. The doctor is unconvinced that these medical conditions contributed in any way to Kenneth's death. Instead, He's called the Suspected Child Abuse and Neglect Program at the Sick Kids Hospital. Now, rather than grieving the death of your son, you are the prime suspect in his death. Not a saint, but not a killer. This is the story of Erin Walsh. Today on Real Life Wrongs, we're talking about lawyers, one of the players in the justice system who aren't sworn to tell the truth, the whole truth, and nothing but the truth, and the one person you hope you can rely on to guide you through the system. But first, let's review the details of the crime.
There's a struggle in Erin Walsh's car. The shotgun goes off. Melvin Peters is shot in the chest, and he dies from his injuries. And that's pretty much it.
Okay. A good lawyer can be one's ticket to freedom. A great lawyer can convince a jury that even a guilty person is innocent. A great lawyer can make the glove look like it doesn't fit. We all want that lawyer. No matter who you are, if you're accused of a crime, you want good lawyering. So, Kel, what is bad lawyering?
Basically, it's when a lawyer doesn't do their job properly or they fail in their duties.
Okay, this is why we begin with simple questions. to have the question, like, why? You've studied for years, you've passed the bar, you have one job. What would make you not perform your duties?
I think it really depends on which side you're on.
I love depends. When my freedom is on the line. Great.
Fair. But really, I mean, each side kind of has its own agenda. We have the crown, and there's often a culture of winning, so maybe they're driven to seek a conviction at all costs. But then there's the defense. And let's be honest, usually they're overworked and underfunded, so you have to wonder, do you really have what you need to do a good job? And I think it's clear that there's a power imbalance in the criminal justice system between the two sides, and it's this power differential that can lead even the best lawyers astray.
Right. Okay. So let's start with the prosecution then. What's their job?
The legal framework concerning the prosecutor's role is clear, and it was spelled out in a case back in 1954, the R.V. Boucher case. And contrary to popular belief, the role of prosecutor is not to win or to lock people up. The Boucher decision was actually really clear, and they said that the prosecutor's role, and like I quote here, they are to be a minister of justice and not to struggle for a conviction. So they have a duty to fairly but firmly lay all of the material facts out before the jury so that they can consider the case.
Okay, let me take a stab at the defense then. For the defense, you help navigate the criminal justice system and mount the best possible defense against the charges. Basically, to advocate on behalf of the defendant and to get the best possible outcome for your client. So, power imbalance. The state, the prosecution, has all the resources, whereas a defendant might have like financial constraints and not necessarily the same access to these same resources.
Exactly. So it can be really hard to fight the same fight if you don't have access to or you can't afford the same experts or testing as the other side. So to help mitigate against this and to try to level the playing field a little bit, the Crown has the burden of proof.
Sorry, I was just messing with my mic. Okay, so what that means is that they're the one accusing you of a crime, so it's up to them to prove that you actually did do it. Simple.
Yeah, exactly. And they'll do this by collecting evidence. And the reality is, because they have the power and the financial backing of the state behind them, they'll be able to collect a lot more evidence than you can in most cases.
Right. So this is where disclosure comes in. Right?
Yeah.
Yeah. So disclosure must be important. They say it on Law and Order all the time. Let's break it down.
Right. So in a nutshell, disclosure is the process where the prosecution has to turn over all of the case information to you, to the defense. And this is because the Crown is making an argument about your guilt, and you have to be able to properly defend yourself against these claims. really, the only way to make sure this happens is for you to know what they know so that you can evaluate the strengths or the weaknesses in the Crown's case. And hopefully, this will help you determine whether you need to conduct more investigation into the charges against you.
And they're supposed to turn all relevant information over. Everything should be disclosed.
Right. And I mean, the case law is clear. Absolutely anything that holds, and again, I quote here, a reasonable possibility of being useful to you, to your side, should be turned over. Problem is, the Crown might interpret the evidence in such a way that they believe it's not going to benefit you, so then it's not disclosed. But the reality is, it should be up to the defense to decide what's relevant to their case.
So let's say that you're charged with murder, and during the investigation, I don't know, your neighbor is interviewed, and they say that they saw you come home with a Walmart bag, but it doesn't seem relevant to the case, so the Crown doesn't turn that detail over. But without knowledge of that seemingly useless bit of information, you as counsel aren't given the choice to decide.
Right. And while your neighbor's statement may seem unrelated to the murder case, it could actually be a key piece of information that you need to help build an alibi or a timeline of events. So really, all of the neighbor's statements should be turned over to the defense to let you determine what's relevant. But reality is, that's not always what happens. It's often the police or the prosecution who are the ones to decide whether that information is relevant to you.
Mm-hmm. And it's simply the defense doesn't know what the defense doesn't know.
Exactly. So if you have a good lawyer who's on their game, they'll file for disclosure. And in a lot of my interviews that I've been conducting for my PhD research, the defense lawyers say they don't only file for disclosure once. Like, they put in multiple requests for disclosure. So they're asking the Crown to give them all the information they're entitled to, but sometimes it's kind of piecemeal.
I mean, why not just ask once?
Because they're going to turn over what they think is relevant. And it's only if you have a good lawyer, like I said, who's on their game, they're going to be scanning through stuff and go, oh, you're making reference to a case report. Well, now I want that case report. You haven't turned it over. Now I have to ask for that to be disclosed, right? And it just kind of almost becomes a rabbit hole.
Is it bad lawyering if you haven't asked repeatedly for disclosure?
Again, I think it depends, right? Mm-hmm. Back to that word. But I mean, if you happen to get everything that you need in your first request, then there's no need to make a further request. But
again, you don't know what you don't know.
Exactly. So is it bad lawyering not to make another request? Well, I would say if that is indicative of the fact that you haven't gone through and, have something that sets your spidey senses off, right? That you're like, ooh, that sounds like something I should be asking about and looking into. So hand it over.
Could be bad lawyering to just take a leap of faith that you're going to get what you need.
Correct. Yeah. Exactly.
Yeah.
And really, again, there's basically two approaches to disclosure. One is you ask them for everything and they literally turn over everything, right? They drown you in boxes of paperwork. Well, back in the old days, now they just send you like a terabyte on a flash drive of miscellaneous scanned documents, right? And now it's up to you as a lawyer to sift through all of these files to find the evidence that you need.
Like that's it's old school paper. Yeah. You ask for the copies of the Walmart receipts and then you get 3 boxes of miscellaneous receipts. Maybe the Walmart one is in there, but that classic, again, all the TV shows, right? Like slamming down all those boxes of paperwork.
This is it, right?
It's tedious to go through digital files.
100%, right? And it arguably
is the labor.
Yeah, and this is what makes it tough for you to find what you need in a timely fashion, right? Because when you have a trial set, you're on the clock and now you have to sift through all this literal or, digital paperwork. And so there's that approach. The other approach is that, like we were saying, they just don't think it's relevant, so they don't turn it over when in fact it might be something you need to help you build your defense.
Right. So like, the neighbor over there who saw you with the Walmart bag, what if the defense has information that they plan on using in their case? Do they have to turn that over to the prosecution?
In Canada, it's not a two-way street. So
why is that?
So the prosecution has to turn over any exculpatory information. So anything that could work to prove your non-involvement in the crime. They have to turn this over to the defense. But the accused doesn't have an equivalent obligation, right? Mm-hmm. But this doesn't mean that they can hide evidence from the Crown. There's no law that I'm aware of that allows the defense to conceal physical evidence. So you might not have to disclose your defense strategy, but you do have to turn over physical evidence that might happen to fall in your position.
Why does this I'm reminded of the Bernardo videotapes. Am I correct on that?
Yeah. So like with the Bernardo case, Bernardo turned it over. Well, he told his defense attorney where the tapes were. Defense attorney finds them, but doesn't turn them over to the police. And
technically saying that's not hiding, but in fact,
yeah. So in that instance, like the lawyer absolutely should have turned those tapes over. I mean, and we can only guess what the outcome of that case would have been had the police, the prosecutor, that side known what was on those tapes before deals were struck and convictions entered, right?
Yeah, absolutely. So where does the disclosure rule come from?
So in Canada, the rules of disclosure were spelled out in the R.V. Stinchcombe case in 1991. And so just for reference, Stinchcombe is the Canadian equivalent to Brady in the US. And I'm only saying this because you hear about Brady violations on Law and Order all the time too.
Yeah.
And in the Stinchcombe case, the Supreme Court said that prosecutors have a duty to disclose all of the evidence in their possession that could possibly be relevant to the case. And even more importantly, they said the rule applies to all information, whether or not the Crown intends to use it at trial. So they might find something and not plan on using it. Doesn't matter. Like, it's still relevant to the case. They have to turn it over.
Right. So this case was important because it firmly answered the longstanding question of whether the Crown could purposely deny the defense of exculpatory evidence. Like in their decision, the justices made it quite clear that I believe the quote is, "The fruits of the investigation which are in the possession of the Crown are not the property of the Crown for the use in securing a conviction, but rather are the property of the public to ensure that justice is done."
Yeah. So, I mean, it's clear, like in offices where there's a culture of winning, they might think like, I found this evidence, this is mine. And the Supreme Court is saying like, it's not actually how it works, right? Like your job is the Minister of Justice. We're trying to find the truth and the correct outcome of this trial.
Yeah. Well, so let's just speak to a lawyer, shall we? We spoke with criminal defense counsel Jason Gilbert. Jason is a trial lawyer who's been litigating cases in both the Ontario Court of Justice and Supreme Court of Justice before both judge and jury. He's a regular guest lecturer at Carleton University Law and criminology classes. Am I right about that? Wow.
Yeah, he's actually come and been a guest speaker for my classes in the past too. I always say to my students, I can teach you what's in the textbooks. I can't teach you like the lived experience. I don't have that. I'm not a lawyer. I don't know what it's actually like. So again, I was really interested to hear from him because, I don't have my boots on the ground. He does. He's got the lived experience. So it's really great to hear from somebody who can give us firsthand accounts.
Let's say I'm in trouble and I've never been in trouble before. I've never had to call a lawyer. I pick up a phone, I get you. How does that conversation go?
Well, the conversation would normally go, so you're not talking now necessarily about the initial custody call, like when you're literally arrested and you're given, your right to counsel by the police. You're talking once, the dust is settled, you've been charged, you've got a court date coming up, you know what you're charged with, and now you're maybe shopping around for a lawyer.
I would say we should start at the very beginning.
Okay. All right. So if we're starting at the very beginning, the first call that I would get from a client, potentially in most cases, would be what we call the custody call. And that's the right to counsel call when someone's first arrested. So when the police arrest someone, as you probably know, there's a constitutional right. The police have an obligation under Section 10B of the Charter to facilitate contact with counsel and to make sure that someone in their custody has been given the opportunity to consult with counsel upon arrest or detention. Now, that right can be waived or it can be declined, but it has to be a meaningful informational component on the part of the police to advise someone of that right, and it's such that they know what they're giving up if they do so.
Your advice to me, if I'm in that situation, is say nothing. Ask a lawyer.
Yeah. So when I get a call,
why is that? Why is that?
So here's really why it is. Because at the point of the initial custody call, I haven't seen a copy of even a skeletal police report, much less full disclosure, which an accused person's entitled to, ultimately down the road. We're entitled to have a copy of all of the evidence that the prosecution intends to use to prosecute the case. And at the point of that initial call, I've seen nothing. The potential client has seen nothing. So I'll usually say, at this point, we don't know what evidence the police have. We don't know what information they have. And by speaking to the police, you might actually be giving them more evidence than they already have. So, for example, they might not even have evidence, they might not have admissible evidence necessarily that you were even present at the scene of a crime per se. And by speaking to them and saying, well, for example, I was there, but I didn't have anything to do with it. If nothing else, you're at least at a minimum putting yourself there. And now you've got to explain away, what you were doing there. And so we don't know, well, do they have video surveillance? Do they have DNA evidence? Do they have a fingerprint? Assuming they don't have a witness that places you there, it would have to be some sort of forensic evidence, like I say, DNA, fingerprint, some sort of video. But until we know that, again, you don't really want to be talking to the police and potentially placing yourself there. The same thing, even in a simpler fact situation like a domestic violence altercation. Again, by trying to explain to the police what it was that happened between you and your partner, you're already probably at a minimum, at a bare minimum, giving them information at the very least that there was some kind of altercation that occurred.
And I think that most people, it's not Hollywood, right? And we see so much of this on television, but the experience when you're in it is obviously completely different.
Yes.
Because your adrenaline is pumping. Who knows what's happened? By saying, I just want to speak to a lawyer, and insisting you speak to a lawyer, hopefully you don't have to insist, you're sort of admitting guilt.
Well, that's a bit of a common sense inference or conclusion that people jump to. Similarly, by asserting one's right to silence, by saying, I'm not saying anything, my lawyer has told me not to say anything. The intuitive sort of takeaway from that is, well, so there is some, truth here that you're withholding. And judges are pretty careful, particularly when it comes to, say, jury cases, in instructing juries that they're not to draw, negative inferences from the fact that somebody exercised their right to silence, because it is a fundamental right. And in fact, I always tell people, just because sometimes the knee-jerk reaction will be, well, are the cops going to be upset with me? Is that going to be looked at poorly if I say, I don't want to talk to you? Or are they going to think I'm rude? And I'll always say, just tell them that was your lawyer's advice. Tell them I suggested you not say anything. And
especially for young people, I would think that, you're, confronted with authority and, very little about the law, and you feel like, this is just time to do whatever they say. Right.
Oh, right. And most of us, I think, we were all that age once. I mean, most of us when we're, 19, 20, I'm not even talking now literally underage, like under 18. I'm not even talking, youth. I'm talking now even young adults, 19, 20, early 20s, university age, whatever, you get into some trouble. We're most of us, depending on the type of upbringing we have, if we're are kind of brought up to believe and see, and rightfully so, I think, in most cases, to sort of see the police as, being the good guys, being the guys that are there to protect us, that are there to, make sure that, that we're safe. And so we kind of intuitively think that if we're arrested for something and are at the other side of being in some kind of trouble, well, if we just explain things, to the detective or explain things to the police officers, surely we're going to be able to sort through this and get through it. And it's just something that it's not to say that way of thinking is necessarily wrong. It just usually isn't the right approach for you when you're the one who's under the microscope and at the receiving end of a police investigation. And, and speaking of, wrongful convictions, I mean, obviously probably the most devastating and tragic examples we have, from our experience in Canadian law are ones where DNA evidence was either overlooked or only came to light, years after the fact. That typically doesn't happen now just because, or anymore, in the last several years, just because forensic, analysis of crime scenes, DNA testing is so routine and is so much, an expected part and parcel of police investigations, at least at the major crimes level. I'm not saying, in every shoplifting and garden variety case, but any sort of major crime, a homicide case, serious case of, an aggravated sexual assault or something, there's typically going to be that kind of forensic analysis of a crime scene. But having said all that, there are cases where, and we hear about them, where disclosure goes, evidence goes undisclosed. And sometimes it's just a case of a judge not engaging in a proper weighing exercise of evidence, that leads to a wrongful conviction. And I think what people have to understand when we talk about wrongful convictions is, again, obviously the most tragic examples of wrongful convictions are when somebody is in a case of actual innocence, where somebody is truly and honestly wrongfully convicted, meaning convicted for something that they literally have not done. You can't think, I guess, of a more tragic situation than that, or outcome than that in a legal proceeding. But wrongful convictions also occur, barring or leaving aside, the issue of actual innocence. If evidence is analyzed improperly, if evidence is improperly admitted, so certain evidence that shouldn't have been admitted was mistakenly admitted, or erroneously admitted by a judge. If there was a violation of somebody's charter right, they sought relief for, but the judge, dismissed the application and said, well, I don't really feel that you've shown that your right was violated in this particular case, when in fact, it was. So leaving aside these cases of actual innocence, to my mind, wrongful convictions can still result in cases where there shouldn't have been a conviction had the proper legal analysis been engaged in, in a case, or had the evidence been approached and assessed properly.
I just wanted to backtrack a little bit to your first question. And Jason had posited like two hypotheses. Do you mean this or do you mean this? So let's say now I'm at the point that I'm shopping around for a lawyer. How do I know that I have a good one? Right? Because I've never had to call. Yeah. Number one.
The phone book anymore? No.
Oh no, that's
the Google phone
First
book.
Google search.
But you know what I mean? Like, how do I know? Like, I'm calling around and I'm trying to retain somebody's services. How do I know that I have somebody who's actually going to put my best interests forward? That I don't just have somebody who's trying to collect a paycheck?
It's like anything else. I mean, looking for for the right medical specialist, the right doctor, the right contractor, to do, to renovate your basement or something. I mean, I don't mean to oversimplify it, but what it really boils down to is finding someone who you're comfortable with, who you can connect with, who you feel comfortable speaking to, and have a kind of feeling of reassurance from, but at the same time also feel that the person, you get a sense of competency and proficiency in the particular area. So
I just wonder, I'm panicked, right? Like I'm like, I got to get a lawyer stat.
Yeah.
How much shopping around am I going to do?
Obviously, if you can get a recommendation, I mean, word of mouth referrals are how I would say 90% of lawyers get 90% of their clientele. It's, based on recommendations, based on somebody else's positive experience with that previous lawyer. And sometimes it's, or more often than not, I should say, it's really a question of clicking personalities. Sometimes, you just, I think you have I have a client in my office or a prospective client. And sometimes I can just tell that maybe, I'm not the guy for them based on how, the conversation is going. And it's not even so much a matter of that I get the sense that they don't think I know what I'm talking about so much as it is, they're looking for a lawyer that, maybe will approach the case or communicate their position this way. And maybe they get the feeling that I'm trying to push it more in that direction when they want to take the case another way. And,
You're like, who's the lawyer here?
Right. And so what I'll always say, to a prospective client is, my job is to give you legal advice. And I'll tell you ultimately, I'm going to tell you what I think you should do. And I'll explain why I think you should do that. Okay. It's not just a matter of, here are your 5 options, you pick what you want to do. I mean, that's not really all you've hired me for. You've hired me to tell you what your options are, but you also, I'm sure, want me to tell you which one I think you should pick. I consider that part of my job too. So, and not only will I do that, I'll even go further and I'll explain why I think you should pick that option. But ultimately, it's your decision which option you pick. If you don't want to take my advice, that's fine. You don't have to. And so sometimes, as I say, if you're shopping around, in terms of which lawyer to go with, I mean, you're going to base it on obviously reputation. You're probably going to Google the lawyer and see what type of, online presence or online reputation they have.
5 stars.
Yeah. You might ask around if you happen to know a friend who's dealt with, a drinking and driving case, something that someone's brother or son or friend has dealt with. You might say, well,
a case that's maybe similar to yours.
Who was that lawyer that so and so used? That's really how I find, in 20 plus years of doing this, people tend to choose their lawyers much the same way as you'll choose someone in other vocations.
So now let's say I chose you, or let's say I've been appointed a lawyer. Just what's the initial, what breaks the ice? Like, do I have to sit there and go, hi, my name's so-and-so, this is what happened, I'm innocent? Like,
and just so you know, just to clarify one point, in Canada, well, in most parts of Canada and certainly in Ontario, you'll never just be appointed a lawyer that you have no say in. The only time that might happen is in a case where you might be actually a self-represented litigant. If you're self-represented in a criminal proceeding, in a very specific type of case, like a domestic violence case or a sexual assault case, there are rules in the criminal code that say the accused person can't directly cross-examine a complainant in a sexual assault case or in a domestic violence case, in what we consider sort of the highly sensitive type cases. And in those types of cases, the court will appoint a lawyer to cross-examine those witnesses. And typically the defendant doesn't have a say in who that lawyer is. It's appointed by the court. Other than that, typically, even if you're a legally aided client, so even if you can't financially afford your own lawyer and you have to go to the legal aid plan, to hire a lawyer, you'll still be able to choose who the lawyer is, although it'll be from a pool of lawyers that accept legal aid cases, but you'll still be able to pick that lawyer. So you would still be the person reaching out to that lawyer, contacting that lawyer for the first time, making an appointment with that lawyer and so on.
Yeah. Okay. And so now we're sitting in a room together, and obviously the first thing out of my mouth is I'm innocent. Like, how does that go? How many times do you hear that? Do you have to sort of draw someone out? Do you have a list of questions?
Yeah. So I'll usually, if it's an initial consultation or an initial conversation where I don't actually have the disclosure yet myself, and I'm just, so my only source of information really is the person who's come in the door to tell me their side of it, I'll usually just start with that. I'll ask them a few personal questions first. Are you currently working? What's your source of income right now? Do you have any children? Are you a Canadian citizen? These are important questions to ask, particularly because there are things like, there are immigration repercussions or immigration consequences for criminal convictions and things like that. So it's important to know right off the bat, certain information. Once we've gotten past those preliminary questions or general questions, I'll ask, okay, what happened on the day or night in question, assuming it's for example, if it were a drinking and driving case, I'd ask them how much they had to drink, what they had to drink, how long before they operated, their vehicle, did they have their last drink. I'll ask them if they have any idea why the police conducted the traffic stop when they did. Did the police tell them why they pulled them over? Was it, for running a red light? Was it for speeding? Was it for running a stop sign? Was it because they had a burnt out taillight or something? I'll ask them if they know, do they recall being told, if they don't have any documents with them, do they recall being told how much they blew, like what their blood alcohol concentration was? Did they contact a lawyer from the police station? Sometimes, assuming I wasn't the lawyer that they called from the station, I'll always ask that question because I want to know, is there potentially a right to counsel issue here, that might be in play. So, so that's how I would usually handle the initial consultation on a drinking and driving.
But when you're talking to your lawyer, that is not the time to minimize Right.
It's not the time to minimize, and
it's best to be honest.
And you'd be surprised how many clients will ask you, as a lawyer, am I allowed to tell you this? Like, do you have a duty to go and, tell the judge or tell the Crown what I'm telling you? And of course, the answer is absolutely not. I mean, lawyer-client privilege is sacred, and it's one of those last remaining, actually sacred forms of privilege. Even doctor-patient privilege isn't what it used to be, and priest and penitent or whatever they call it isn't even quite what it used to be. Whereas lawyer and client still is very much, the rules of professional conduct only give very, very, very rare exceptions of when that privilege can be opened up or
do you love that part of your job? Do you like being that secret keeper, like that vault?
Well, I've never really thought of it, in that terms of, in terms of, liking it or loving it or disliking it. I've always just sort of accepted it as part of the job, and it's just routine. It's like I don't.
It's not like you've ever been like, I just want to tell somebody this.
No, not actually. No. I get where you're coming from, thinking that would be something that maybe you'd feel like, I just got to get this off my chest or something.
Why I'm not a lawyer, Jason.
But I think we're just so trained with that mindset from such an early stage, particularly because of a Supreme Court of Canada decision from a number of years ago called Stinchcombe. That's kind of the most significant decision that sets out what the state or the Crown's disclosure obligations are. And in a nutshell, the accused is entitled to and has a right to have disclosed to them any evidence, any material that the Crown intends to use in the prosecution against that accused person. Even beyond that, it wouldn't really be enough. Like, for example, if something went undisclosed or was in the possession of the Crown that they didn't disclose, it wouldn't be enough to simply say, well, we didn't disclose it because we didn't intend to use it anyway. I mean, that wouldn't really be an excuse. It would be anything that is, from a professional common sense standpoint, determined to be relevant, to the prosecution.
Can we trust common sense here? Can we?
For the most part, yes. For the most part, yes. But and here's the but. So typically, what we do is, when I'm retained as a lawyer, when most lawyers are retained by a client, we submit a written request, very brief request in writing to the prosecuting Crown's office, just saying, I've been retained to represent so-and-so, please provide any and all disclosure in this case. And that's
possible. Is it possible that a bad lawyer, and that may not be your favorite term, but is it possible that a bad lawyer would not request to be given full disclosure?
It's possible. It's possible that a lawyer might not necessarily make the request in writing, even if they don't. And I'm not suggesting that it's that it's a good practice to get into. Even if a lawyer doesn't request the disclosure in writing, that doesn't obviate or it doesn't negate the Crown's obligation to provide it. So the Crown couldn't just, show up on the trial date and say, well, we never received a disclosure request. And so, we've known that, Mr. So-and-so or Ms. So-and-so has been representing this accused all the way through, but they never requested disclosure. So, we never send it over. It's a
guarantee that it gets sent over.
Yeah. I mean, it would, let me say this, it would look very bad on the defense lawyer if come trial, they showed up with no disclosure and then just, whined and complained about it on the day of and asked for an adjournment because they'd never gotten disclosure. And then, the first question that would be asked is, well, did you request disclosure? The lawyer says no. It would look very unprofessional and verging on, if not already reaching, an incompetence level.
That would be fire my lawyer time.
It would be fire my lawyer time, but also I think grounds for a professional complaint already.
Mm-hmm.
I think that there would be, potential professional liability there.
So it's unlikely.
It's unlikely to happen.
Is
that a lawyer would just show up on the trial date and say,
Mm-hmm.
I never received disclosure.
Yeah.
And now there are certain types of disclosure that the Crown is not obligated to provide, okay, but they still have to notify the defense of its existence and give the defense the opportunity to make a case for obtaining it. Let me give you an example. Something that a complainant in a case, an alleged victim, a Crown witness, if it's material that person is deemed to have a right of privacy over. So let's just say there are medical records, psychiatric records, employment records, educational records that are not necessarily, strictly speaking, the product of the case. They don't relate to the specific charges, at play, but they could have bearing on these sort of potential historical aspects of the case, surrounding circumstances, credibility, reliability of a witness. What the Crown typically does is they'll send us a kind of a boilerplate notice saying, this is just to put you on notice that we are in possession of what we consider to be third-party records. In other words, records in the possession of a third. We've become aware of records in possession of a third party,
and they are obligated.
They're obligated to notify us of their existence, but not to disclose them to us. Mm-hmm. So they could be CAS records. So let's say we're talking about a domestic case involving, former spouses, and there have been prior incidents of acrimony, between the couple that the CAS has been in the middle of, and so records of some of those interactions are in the possession of the Children's Aid Society. The Crown may become aware that those records exist, but they're not required to disclose them to us. If we want them, okay, we would then have to bring what's called a third-party records application, and it's a very complicated, convoluted process that's all set out in Section 278 of the Criminal Code, and we've got to be able to demonstrate that the records are likely relevant, to an issue at the heart of the case.
Why does it have to be so complicated?
Well, it's the reason that I guess it's as complicated as it is because people's personal privacy interests or their right to privacy over certain types of information is considered to be so sacrosanct, whether it's psychiatric material, records of employment. It's, what we would typically, I guess, think of as sensitive information. Courts aren't going to order that kind of information to be shared with others unless there's demonstrated to be a real good reason that could potentially impact on the, have a realistic prospect, a reasonable prospect of actually impacting on the outcome of the case.
So as a lawyer, you're sort of weighing how much is this going to be worth this process? Right.
And, frankly, it takes some experience because there are lawyers who, for example, in just about any sexual assault case, let's say sexual assault prosecution, will, upon being informed or becoming aware that that say the complainant has a psychiatric history, the default will be immediately bring that third-party records application. Let's go after those psychiatric records, or employment records, or what have you. And sometimes, sometimes there could be some real purpose, or there could be a real benefit, I guess, to the defense that's being advanced to having access to that type of information. But there could be a sort of lucrative purpose. But other times, it's almost that old, be careful what you wish for, be careful what you ask for, because very often when those types of records are turned over, or what we find is a lot of history of some very sensitive information with respect to a complainant, where we're getting information about a very sympathetic psychiatric history and evidence of a very vulnerable individual. But it's not necessarily going to be helpful to the defendant's case. So, as I say, I would say as a defense lawyer, you want to operate within the parameters of being very careful what you ask for, and that unless you're quite confident that it's going to bear some significance, to a defense in the case, like sometimes, for example, some sort of personality disorder, or history of pathological, dishonesty. Yeah, that's going to be quite important. But if it's just being able to demonstrate that somebody is suffers from long-term depression, or somebody suffers from bipolar disorder, that doesn't necessarily have any bearing on their reliability as a complainant, I'm not so sure how much you necessarily want to go after information like that.
So who's making that decision once the paperwork is filed? Is it a clerk or a judge?
It's the judge ultimately. So for example, if you bring a third-party records application, the records are subpoenaed to court. A judge has to have a look at them and determine whether or not they're going to be and make a relevance determination in respect to them. So first you have to show a likely relevance before you even get to that stage, before you even get to the stage of the judge cracking them open and making any kind of assessment. You have to, you've almost got to argue it blind, because you've got to make a case for why these types of records, generally speaking, would be likely relevant, to an issue sort of germane to the case. If you get past that initial stage, then the judge examines the records and makes a determination on whether they're going to be admitted.
And we can move on from this, but I'm just curious: have you ever applied for that, or? It's not uncommon at all. Yeah.
Okay.
Yeah.
Okay.
So that's a little bit of a tangent, in terms of disclosure. But typically, just from a keeping it simple standpoint, yes, any relevant evidence that the Crown intends to rely on in the prosecution, they have an obligation to turn over and disclose to the defense. And if after reviewing disclosure, as a defense lawyer, I feel that something is missing, and I think I touched on this the last time we talked. So for example, if the disclosure alludes to a previous history with police between the two parties, involved, let's say, it wouldn't necessarily be something that the Crown would disclose in the first instance, because it's not necessarily part and parcel of the current prosecution. But so that would typically be the stuff of a follow-up disclosure request, where the defense lawyer would make a request for additional disclosure from the Crown, saying, look, in reviewing the disclosure that I have received, it's come to my attention that there was a prior incident between the parties that the police had to, respond to and did respond to, and there's a report that was generated based on that from, October 22nd, 2018. I'm requesting disclosure of that prior occurrence report, and we'll typically get it.
Mm-hmm.
So can I just, as a non-lawyer, disclosure is something that kind of baffles me, because my understanding is you are asking for something that you don't know what you're asking for, right? You don't know what you don't know, and you're asking the Crown to hand over whatever it is that you don't know. So how do you know that you're getting what you don't know?
Well, okay. I mean, I guess short answer is you don't always.
It seems like a big leap of faith, I guess, is what I'm getting at.
And that's why, I mean, there are these disclosure obligations that are, are required of the Crown by law. And I mean, if the Crown, if the prosecution, well, first of all, if they knowingly withheld something that was relevant to the case, I mean, that would be serious prosecutorial misconduct, and that would likely be, that could be seen as malicious prosecution. And even if they negligently, just kind of inadvertently didn't turn something over, I mean, that would certainly be, if it were discovered on or shortly before a trial date that there was something that they had failed to turn over, even inadvertently, like, in other words, not with any malice, it would certainly be grounds for an adjournment. In other words, the accused wouldn't be forced on, to proceed to trial if there was a piece of pretty significant disclosure that was only being handed to him, 3 days before trial, without any real opportunity to review that or prepare his or her defense in consideration of that piece of disclosure. And if it was something that was only handed over in mid-trial, if it was something that was handed over in mid-trial, that is then determined that's determined to potentially maybe have impacted on trial strategy or on the way the defense would have conducted their defense had they known about that piece of disclosure, but just didn't have the benefit of it. I mean, it could even be grounds for a mistrial. And certainly any delay that was caused as a result of that would be at the feet of the Crown. So, I mean, about the right to a trial within a reasonable time, and it's a constitutionally guaranteed right in Section 11B of the Charter. And the Supreme Court, in a case called Jordan, back in 2016, kind of reconfigured the law on delay and set pretty fixed terms, 18 months for a trial in the provincial court and 30 months for a trial in the superior court. And anything that exceeds those guidelines, the Crown more or less has to justify and demonstrate, to the satisfaction of a judge, why it took longer than that to get.
When you say a reasonable amount of time, I think that is one area where, civilians like me don't always realize how slow the process is. And I guess television has done that, where it really looks like everything just, happens in a week. You go to court and you get the verdict, but it's much the opposite.
And there's that whole exceptional circumstances exception within that. So, I mean, if the Crown can justify a delay, beyond the 18 months, for example, due to exceptional circumstances and satisfy a judge that the circumstances were indeed exceptional, they could effectively, avoid the case being tossed, for unreasonable delay. So, for example, the COVID backlog. I mean, the pandemic created huge jams and backlog and delays in the court system. There are limits. I mean, for the next 5 years, the Crown isn't going to be able to fall back on COVID delay to justify why prosecutions have taken as long as they have. But certainly at this point in time, if a case went back to 2020 or 2019 and it was only, say, reaching trial now, some 2 or 2.5 years later, chances are the Crown would be able to demonstrate that fell within reasonable sort of COVID backlog delay, and the fact of that being an exceptional circumstance that we just couldn't have accounted for or couldn't have contemplated before the pandemic hit.
So just in the sort of defense attorney role, we're speaking to you because, we want to know what a good lawyer does. Mm-hmm. And I'm just wondering, without naming names, or even possibly being too specific, have you ever witnessed just bad lawyering?
Yeah, certainly I have. I'm trying to think of cases that I've actually sat in on where that's been the case. And when you ask about bad lawyering, I mean, I take that to mean more than just, I would have done this differently, or I would have argued this differently, or why would he ask that question? I take it to mean lawyering that falls below a professional standard of competency. I've heard about those types of cases. To say that I've actually sat in and witnessed that type of lawyering, I can only think of one case really that I recall experiencing that, and it was a case, believe it or not, in of all forums, traffic court, and there was somebody arguing. It might have been a stunt driving case or a speeding case. I don't remember exactly what the traffic offense was. But in the middle of the proceeding, finally the prosecutor had sort of had stood up. I guess it was becoming concerned about the quality of representation and the competence level, and brought it to the justice's attention and said, I'm very concerned about the qualifications of and the competence of the representation that this individual is getting. And I think the justice of the peace said, I was starting to think, the same thing, and kind of called a recess. And basically, I think that the case had been ordered, adjourned or something, or there was a recommendation that this particular litigant, seek new counsel. But yeah, that could certainly happen and I've heard of that happening in actual criminal courts as well. There's a case that I recall off the top of my head in the last few years where a lawyer was involved, and basically so as to avoid declaring a mistrial or as to avoid sort of professional proceedings maybe being initiated against that lawyer, or some sort of competency inquiry, another lawyer was called in to assist or to sort of sit second chair with this other lawyer, and that's how I think it was handled in that case.
I would imagine in most cases, you're just going to have, you'll have good lawyers and you'll have great lawyers, and it's few and far between, I would hope, where your lawyer just is incompetent in some way.
Right. Yeah. No, I agree with that.
Yeah. And what quality do you think it takes to be a great lawyer? What is it that makes a great lawyer?
I think, well, preparation is key. Being, up to date on the sort of leading principles, legal principles that are going to be at play in a particular case. So, I mean, for example, if you're doing an impaired driving case, that's a very specific, almost
like specialized?
Well, almost. I mean, it's more than just cross-examining witnesses, to expose issues of credibility and testing a witness's memory and it's not just a fact-driven trial, like say a typical domestic assault prosecution. It is specialized, and there are it's a very technical type of prosecution and case to defend that calls into play timing, like how long between the time of driving and the time that a breath demand was made, a demand that that an individual provide a sample of their breath, and the timing between the time of driving and when the actual breath sample is taken, or for example, if it's not impaired by alcohol, but if the allegation is impaired by a drug as opposed to alcohol, then it's not as much an exact science as impaired driving, because with impaired driving, you're getting actual blood alcohol concentration readings. You're getting an actual measurement. With drug impaired driving, I mean, usually you do get the results of urine samples. So you get the determination of whether there is the presence of those substances or a substance in the person's system at the time. But it's a very technical sort of exercise to be cross-examining and questioning a drug recognition expert. So yeah, it's a police officer that's gone through certain types of training to be declared, what we call a DRE or a drug recognition expert. And it's a lot more than just cross-examining a civilian witness.
So a good lawyer would, regardless of the offense, would be able to go and prepare all of that. Although I'm also hearing, is the almost specialization of these situations like getting a geography teacher teaching you French. Like, do you know what I mean? Like, is it, wow, get hit in the head more often, Cal. Like, do I need to find the specific lawyer for the specific case I'm dealing with? Or, really lawyers are supposed to be able to cover?
They are. And I mean, well, for example, if they don't, then, again, it's like what you said about the disclosure. We were talking about with the disclosure, like, you're putting a lot of faith in, it's, I guess it would be the same if a lawyer is offering services or is agreeing to take on a case in any type of dealing with any type of offense or prosecution, then the client is entitled to assume, based on that, or that the lawyer is qualified to represent them in that particular area, because the lawyer's holding themselves out as someone who is competent and qualified to do that. So you do have lawyers and criminal lawyers who will say, look, I don't deal with these types of prosecutions. I don't do, impaired driving cases, or I don't do sexual assault cases, or I only do drinking and driving cases or driving offenses. There were a couple of lawyers over the years who had very sort of pigeonholed, specialized criminal practices, and they were considered like the go-to lawyers, for drinking and driving cases. So, it's kind of a subset or a subcategory of expertise, if you will. But by and large, most criminal lawyers hold themselves out as being, competent or qualified to represent clients charged with any criminal code offense, of which impaired driving is one, as well as Controlled Drugs and Substances Act offenses, so narcotics offenses. That's what most of us do, and that's what and as I say, if you take on such a case, then you would be deemed to be holding yourself out as qualified to do that.
So you basically have to know a little bit about everything.
Yeah.
Right? If you get called into a forensic case versus a driving case versus a sexual assault case, like those are all vastly different knowledge bases that you have to have, and you have to be able to tap into all of those, or at least know enough to know that you don't know enough.
Right. And have the capacity and the insight and the willingness, either the staff or the willingness to do the research that's required and read up on areas that you're either a little rusty in and not up to date on, or have very little knowledge of at all, if you're going to take it on.
Or perhaps be willing to put your ego aside and say, that's not my area. I can't do that. Right. Because I feel that, and I could be totally wrong, but I feel that a lot of people don't want to admit that they don't know something, or they can't do something.
And a lot of lawyers, look, it's like anything else, I guess. Lawyers are in, they're earning a living, and this is their source of income and their livelihood. They don't want to. A lot of them don't want to turn away potential business, right? From a very simple standpoint. So, unless you're a really, really pretty consistently busy lawyer, and you've got a 2-week trial, and then maybe a 2-day break, and then starting another 3-week trial, and maybe a 1-week break, and starting another 6-week trial. Unless you're a lawyer that's constantly working, and you look at your calendar and your diary is full for the next 18 months or something, in which case you could sort of afford to turn away business or decline. Most lawyers are, it's just part of our sort of mentality, that when a potential client calls and says, look, I'd like to hire you, we have them in and we take them on if they want to hire us. So yeah, it definitely takes some ability and setting aside of an ego to be able to say, if you are confronted with that type of case, you know what, I think I know of someone that would be better qualified to help you with this than I am.
Mm-hmm.
Yeah.
And so you've been practicing for
it'll be 21 years in February.
So would there be anything that somebody would contact you with and say, you would say, I'm not comfortable trying that, or I'm not comfortable taking that?
I mean, as it is, I limit my practice to criminal cases and what we call child protection cases. So I do CAS work as well. Anything outside of those areas, that's exactly what I say, because I get a lot of calls, especially, given that child protection work is a subset of family law. I get a lot of calls from people wanting help with just straight family court cases, just, custody and access and that. And I will, and technically, I mean, my professional liability insurance is topped up such that I can take on, any type of case I feel like taking on. But I don't take cases other than criminal or child protection, and I'll identify that immediately and say, well, no, and they'll start saying, well, the CAS has been involved, or they were involved in the past, and they're involved on the periphery, and I'll say, well, no, if it's not actually a family case that is based on a CAS, a children's aid protection application, then it's not an area of family law that I practice in, and I'll immediately recommend somebody else. So and that would obviously go for any other type of case, be it corporate, commercial, civil litigation, that sort of thing.
Have you ever felt you've gone above and beyond what is in your job description?
Yeah, I do. There are times, that I feel that I have provided, a client with a quality of representation that is, beyond what was necessarily called for in the case, to achieve a favorable result, but went that extra mile and, achieved something well beyond that anticipated result. Yeah, it's definitely happened.
Do you ever see, are you witness to a lawyer who seems like they'll just go to any length to win? Like, have you ever witnessed that, going like, I don't know, like that it's
like bend the rules,
trying to get away with, like really working either the jury or the content of the case in a way where you're like, that is just, it's kind of dirty pool, but it's not outside the rule book.
Yeah, I've seen that. Let me just say this. I've seen, tactics that I certainly wouldn't feel ethical using myself. Yeah.
Is there any recourse for that?
Mm-hmm.
Yeah. I mean, if it's to the point of professional misconduct, I mean, there are rules that we're governed by, insofar as our law society, that forbids us to, engage in what's termed as, say, sharp practice. In other words, being playing fast and loose with the truth with the other side, or we're officers of the court, and we have an obligation to be candid and honest with the court. So yeah, I mean, if it was determined or discovered that a lawyer was anything less than that or short of that, then yeah, that could be grounds for a potentially contempt proceeding, or certainly a professional discipline, by the law society. And I'll say this. I'll say this. I've experienced situations over the years in front of judicial officers, in front of judges, where I have felt that not so much, not only the quality of judging, I mean, that sometimes falls short, but the demeanor of the judge on the bench has been what I would say, term as unacceptable or abusive and unprofessional. I've certainly seen that as well. So it's
who governs that?
Well, there's the Judicial Council. There's a Judicial Council both provincially for provincially appointed judges and federally for federally appointed judges. There's Ontario Judicial Council and Canadian Judicial Council.
I would think that would be complicated paperwork.
I would imagine so. It's not something that I've ever gone ahead and done. And I think a lot of us think in terms of, well, if you're up there, you're sort of untouchable. No, I mean, judges have an obligation to conduct themselves with a certain, within certain parameters and, of professionalism as well, just as lawyers do. I've certainly seen that as well.
So would you say that lawyers sort of keep themselves in check with each other? Does that ever happen where, you take someone aside, or there's brotherhood of lawyers that kind of keep things on the level?
I suppose. I mean, I have seen, I've seen lawyers, a lawyer take another aside, and say, look, I just want you to know that what just happened in there, you really want to be careful, or before going too much further down, the path that you're going. I've seen sort of friendly kind of warnings like that. It's happened.
I mean, do lawyers who bend the rules, assuming that there are some, do they last? Do they succeed?
Not usually. Not usually. I mean, that kind of, that kind of belief system that, the people who are prepared to bend the rules are the ones that, go furthest. That doesn't really apply in our profession with much, success. Mm-hmm. We find that lawyers who conduct themselves in that way tend to fade pretty quickly. Like they don't last long because they just can't do it for very long without being called out.
Right. Yeah.
And once they're called out, more than 2 or 3 times, it's just, they're pretty well done.
How is lawyering in real life different than the lawyering you thought it was going to be, or what people see on television?
So I'd say if the most dramatic difference that you would see is the length of time that trials take, particularly up here, and because there is some resemblance, when you see the length of time that say even a homicide trial takes in the States, you'll see, murder trials will be done in 5 days or 10 days down there, whereas here it's more like 5 weeks or 6 weeks. So the length of examinations, cross-examinations, and the questioning of witnesses and the sort of intellectual gymnastics that we go through, in terms of pretrial motions and, different stages of motions and, admissibility of evidence until the actual case unfolds. You would definitely think from watching legal dramas that it's a much quicker and faster paced process than it is. It really is a pretty slow, painstaking process in the major crimes trials. I don't think most people really envision it as this kind of multi-week process, a trial. I think people think that it's over and done with a lot faster than it is, and that's probably the biggest area of disappointment that I see from the various players, be it witnesses in the case, they're subpoenaed on to come down to court on a Monday morning, only to be told at 4:30 that they have to come back the next day because they haven't been reached or there hasn't been time to get to them. People think it's going to be a lot faster than it is. Family members of witnesses, get kind of demoralized or feel a little let down by the system because of how long things take. So yeah, that's really the biggest difference I would say from the impression that TV and movies gives to the process.
Is there anything that you would like to see changed or fixed in the system if we could snap our fingers and give you that right now?
I do think that there are times when, going back to the third party records subject that we were talking about earlier, I do think that there are times when that is abused and taken to extremes. And in my view, in my humble opinion, when the records at issue specifically pertain to the parties involved in the litigation. So, for example, when we talked about, CAS records or family court records or, psychiatric records, let's say, where a complainant has specifically talked about, the subject matter that they're then complaining of, in the criminal prosecution, that sort of thing. I think that there should be more of a presumptive, admissibility or entitlement to the disclosure of that type of material. I think that our third-party records rules and some of our disclosure rules have narrowed too much. And I don't want to say because it's a rabbit hole when you start to frame it that way or phrase it that way. I don't want to say that they have narrowed too much in favor of complainants or in favor of that's not. But they have narrowed too much to the detriment of defendants and accused persons. I'll say that, and I sometimes find it frustrating in prosecutions the sorts of things that we need to jump through hoops to get access to that just add to hours and hours, if not sometimes days, of what sometimes seems like frivolous litigation. Fighting over. I'll give you a quick example before we break. Text messages. There was a recent case I did where I was informed that the Crown had certain text messages that a complainant had provided to the police, in the investigation of a prosecution, and the Crown had asserted a third-party privacy interest in the complainant over these particular text messages. So I would have needed to bring an application of this nature, to get them. And it had turned out in this particular case that in the complainant's statement to the police, they had basically described what the text messages were. So even without getting the text messages, I basically knew what they said because it had been discussed in the interview between the complainant and the investigating officer. So I realized very quickly that no, I don't really need those text messages. They're not of any interest to me. They don't really concern my client. In any way that I was interested in exploring. But initially, I had asked the Crown, why don't we do it this way? Can I attend the Crown's office, have a look at the text messages to at least know if there's anything that I would be interested in? And if there is, then yes, I'll bring this application and we'll do this dance and I'll do what I have to do to try and get them. But if there isn't, then we can shut it down, and there's no reason to set court time aside and have you respond to an application for something that I'm just shooting in the dark for. And the response was no, we can't do that. If you think you want them, bring your motion or bring your application. So as I say, that to me that's frustrating and it's wasteful and it's not an economical or efficient use of resources. I mean, everybody, you, me, everybody else is paying for this sort of litigation. And I think sometimes that if the public knew what it was that was being litigated, that their tax dollars were funding, they may not be too thrilled with some of those answers.
Absolutely essential that that you are getting full disclosure. How do you know that your lawyer is doing that? Do you have to tell your lawyer, remind them? What's the situation for you?
No, we send out a written request. It's pretty much a form request to the Crown's office, just notifying them that I've been retained to represent so and so. This is their date of birth. I understand their first court appearance is scheduled for November 29th. Could you please provide me with full and complete disclosure, any and all disclosure available in the case.
Do you ever feel like you don't get that? Do you ever feel like, how do I know I have everything? Because one lost receipt could mean...
As you go through the disclosure, you'll see sometimes it'll say the parties were dealt with previously on, such and such a date, which led to police report, 22-593. So suddenly now you're like, okay, so that hasn't been disclosed because it has nothing to do with, they're taking the position that it has nothing to do with this incident. But now I already know about a prior occasion where the police attended in relation to these same parties and had to, ref an incident or break up an incident. Maybe it didn't lead to arrest or charges being laid, but I'd kind of like to know what happened there. So then I'll request additional disclosure. I'll say, well, in the disclosure that I have received, there's reference to a prior police report, 22-whatever, that apparently involves these very same parties. Can you please provide me with disclosure of that? And
now, to me, that's good lawyering.
Yeah.
Right? There may be other lawyers who don't, maybe look into what they're not getting, but that would be a very special feature.
And so there very much is disclosure that's not necessarily provided first instance or isn't considered to be required disclosure. Like in other words, it's not seen as falling within the Crown's obligations under Stinchcombe, which is that historical or fundamental Supreme Court case that talks about what the Crown's disclosure obligations are, and we kind of have to request it separately or go after it. And most of the time they'll give it to us, but if we don't ask for it, they won't. So, for example, a complainant's criminal record. If you get the impression that the person who's, the main Crown witness has a bit of a shady history themselves, you're entitled to ask for the criminal record of that person. And typically you would. I mean, if especially if it's, a guns and gangs case, a major crimes case where basically it's like a rat's nest. Like everybody involved in this case is kind of shady or someone that you wouldn't necessarily, buy a used car from, so you would probably be handicapping yourself a little bit if you didn't ask for, the criminal history of the witness that you're about to cross-examine.
Now, do you ever feel like when you hear your client's story, the more detail they give you, has there been instances where you've heard their information and said, what, we don't have everything. We haven't been disclosed everything. Does that ever happen?
Yeah, it has. So sometimes a client, like recently a client told me that they had an episode, like it's kind of related, I guess, to what I mentioned about the previous police reports. So sometimes it's not necessarily referenced in the disclosure that you get. Sometimes a client will say, a couple of years ago or a few months ago, the police, came and had to break up this incident, so so suddenly you're being told by your client that there's some prior altercation that could have given rise to maybe some bad blood, between the parties, and you definitely want to explore that. You definitely want to know what happened there.
This is why you want to tell your lawyer everything.
Yeah.
They're the vault. Just tell them. Fantastic. So for an episode on bad lawyering, we wanted to be sure to speak to a good one, to hear how a good or a great lawyer thinks, to know that the good guys are out there. So it was a pleasure speaking with Jason. We've talked a lot about how the Crown can contribute to a wrongful conviction. And we've also we've talked about the defense. With wrongful conviction cases, we usually hear about the ineffective assistance of counsel. So it's not really about the right to an attorney that's an issue. It's the adequacy of counsel. Many accused individuals end up with legal aid who may be overworked, underfunded, or even inexperienced.
Exactly. And on the defense side, the ineffectiveness of counsel can be a big contributor to a wrongful conviction. But the problem is, how do we determine if the defense attorney was actually ineffective, right? I mean, the basic standard for a lawyer to be found ineffective is that the counsel's efforts must have been so substandard as to render the trial a mockery of justice.
Wow, the mockery standard sounds vague, unpredictable, which would make it difficult to apply consistently. No, like it puts a heavy burden on the defendant to prove that their counsel didn't act in the best interest of their client. It deprives the defendant of a reasonable chance at acquittal if counsel's errors are serious and prejudicial, but not so blatant as to render the trial a farce.
Yeah. Right. And sadly, there are way too many stories of lawyers who were assigned to represent indigent defendants charged with capital offenses in the States, obviously. And they were found to have slept through the presentation of evidence, arrived at the courthouse drunk or high. They were unable to recall a single relevant fact. They failed to conduct any investigation. They didn't present any evidence in mitigation of their client's sentence because they didn't know how or what to do, right? Like, this is a pretty sad list of, misdeeds, if you want to call them.
Despite all of that, these lawyers are not seen as having provided ineffective assistance.
Yeah, that exactly, right? So it seems the deck is stacked against the accused if they end up with one of these lawyers because, the research have pointed out time and time again that the standards, as you can see from this list, are really high to be able to prove that you got ineffective assistance at counsel. And, one of my favorite quotes in the literature says that when it comes down to it, if a mirror fogs up when placed beneath the lawyer's nostrils, they're not ineffective.
Wow. Like, how is this not ineffective? Like, you're not just a bad lawyer, you're possibly a bad person. Your job is to defend. It's argued that when counsel neglects to defend their client vigorously, it's akin to having no counsel at all. Like, the consequences, rather than falling on your lousy, like the consequences don't fall on the lawyer. They fall on the client, who's now probably going to jail or being fined, paying hefty fines or whatever it is. Again, where is the accountability in the system?
Yeah. I could not agree more with all of that. And probably part of the problem is that the justice system doesn't like to overtly place blame on the individual defense lawyer, right? There's strong collegial relationships within the legal profession. And, these probably can prevent lawyers from attacking colleagues for mishandling cases. Think of it like doctors who don't want to testify against other doctors or police who don't want to testify against other officers.
Right. Instead, blame is placed more generally on systemic problems like inadequate funding, lack of oversight, heavy caseloads. And then on top of that, you add another challenge of proving ineffectiveness before saying that the defense attorney's performance was inadequate. You'd have to prove that the lawyer's actions were the result of incompetence rather than being tactical decisions.
Yeah, and that's an incredibly tough hurdle to overcome because the courts don't want to second guess an attorney or a lawyer's tactics or strategies. In some cases where you think the lawyer was ineffective because they didn't make opening or closing statements or they didn't cross-examine witnesses, it can easily be argued that these were actually tactical decisions and they were made in the best interests of the client.
Right. Yeah. Yeah. If that's not considered ineffective, I don't know. What are some examples of providing ineffective assistance of counsel?
So one thing that has been noted as ineffective assistance of counsel is misleading a client to plead guilty.
Okay. So for example, if they tell their client that they'll get a much better deal than what is actually even possible, then the client is unable to make a fully informed decision.
Exactly. And something else that's considered ineffective is the failure of counsel to investigate the facts.
Right, because a lawyer who doesn't fully investigate their client's case and seek all the facts might as well just show up and stand in the courtroom. I mean, seriously, save yourself some money and just put a pylon in your lawyer's chair.
Well, really, if they're not working for you, why hire them, right? And something else that's kind of tied to this is if the lawyer doesn't have enough time to prepare for trial, this can be used in a claim of ineffective assistance. Obviously, if they don't have time to prepare, they can't properly defend you or respond to the accusations that are being made by the Crown.
Right. So, yeah, I think that goes without saying that if the lawyer doesn't understand and interprets the law improperly, they obviously can't properly defend their client. So let's go back to the Walsh case.
So we know that Erin seemingly befriended 3 local men when he got to St. John, and he discussed his plans to sell the drugs. And we also know that Erin met back up with these 3 guys the next morning to continue their conversation about selling the drugs. So we may not know exactly how Erin's keys ended up in the hands of the 3 locals, but we do know that the 3 of them conspired to rob Erin of his drugs and the money. We also know they forcibly confined Erin and his friend George in Erin's car. It's unclear who pulled the trigger, but Erin knows it wasn't him. And he knows he wasn't responsible for Chi-Chi's murder.
It's interesting. At trial, the 2 surviving locals were called by the prosecution to give their version of what happened. Because their testimony gave no indication of interest in or even knowledge of the drugs, they were seen to be far more credible, than Erin, and the jury found it easier to believe their words than the word of a drug dealer. So based on their testimony, Erin was convicted by a jury in less than an hour and sentenced to life in prison with no possibility of parole for 10 years.
But Erin knew he wasn't guilty of the murder, but he didn't know what he could do about it, right? So he wrote to every official he could think of to try to uncover more information about his case. And most of his letters were not well received. But finally, 28 years after his conviction, he received a very helpful response.
As a result of his letter writing campaign and a request for access to information, Erin finally received the news he had been waiting for. The New Brunswick Provincial Archive sent him the complete Crown file of his case. Would that have been a pretty big case? Would that have been a lot of paperwork?
Yeah, well, more than he ever had, obviously.
Sure. Well, what he found would ultimately clear his name. As Erin reviewed the Crown file, he learned that the Crown had failed to turn over a number of potentially exculpatory pieces of evidence, pieces that would have helped to clear his name. Like, the Crown was aware of a conversation that took place between the 2 locals while they were in their holding cells after being arrested. The conversation made it obvious that they were responsible for Chi-Chi's murder.
So with the new information in hand, Innocence Canada helped Erin to file an application for ministerial review late in 2006. And, this was on the basis that the new material proved his innocence. And as if this fight wasn't enough for him, while fighting to clear his name, Erin was diagnosed with terminal cancer and only given 6 months to live. So, now Erin's not only fighting to clear his name, but he's also fighting to live to see the day that it would happen. And in February 2008, the Minister of Justice approved Erin's application to have his case heard again. And the New Brunswick Court of Appeal did an absolute solid in expediting Erin's case, given his prognosis.
So where is he now? And was there any compensation?
So Erin's case was pushed through the court system quickly because of his failing health. And also because he had the Crown's statement that he had suffered a miscarriage of justice. On March 14, 2008, the New Brunswick Court of Appeal found that no reasonable jury would have convicted Erin had they been made aware of all of the information that had been kept in secret in the Crown's file. So Erin's conviction was quashed and an acquittal was entered. And after more than 3 decades, Erin finally succeeded in clearing his name.
3 decades.
Yeah, that's a long time. But after being acquitted, Erin decided to take on another battle, and this time for compensation for the 3 decades that it took to clear his name. In October 2009, he reached an out-of-court settlement with the province of New Brunswick for an undisclosed amount. And really, it's not important. The main thing is he did live to see all of this happen. But despite all this, his health continued to deteriorate over time. And, because it took so long to clear his name and to get compensation. And he lost his battle with cancer in October of 2010. So I think it's really important that we all just take, even just a brief moment to appreciate the strength and the determination that Erin was able to gather to be able to set the record straight, right? In 2006, he was given 6 months to live, and he somehow was able to continue fighting until he saw this thing through to the end in 2010. Yeah. And, I have no words and nothing but the utmost respect for him. And while he made the most of his time as a truly free man, he hardly had the time to enjoy what it actually meant.
If it should ever come to pass that you require counsel, you might think, this is like a box of chocolates. You never know what you're going to get. Well, you do have options, and it's up to you to choose your best fit. Ask questions and also listen carefully to how you're being instructed. And the good news, most people are in it to win it.
The world of wrongful convictions is a living hell for individuals who end up in it. And believe it or not, it could happen to almost anyone. Know the law, know how to look for flaws in the system, understand how marginalization works, and most of all, talk about it. Thanks for listening. I'm Kelly Lozon.
And I'm Kelly Vanson. We'd like to thank our guests for their insight, stories, and expertise. And we'd like to thank you, our listeners, for your interest in the world of wrongful convictions and for sharing our podcast. For more information on wrongful convictions, visit our website, realliferongs.com, and email us at hello@realliferongs.com. You can find us on Twitter, LinkedIn, Instagram, Facebook, and anywhere you find podcasts.
All of us could falsely confess to something.
They blew it all out of proportion, and they got away with it.
Even a country like Canada has people who are charged and convicted of crimes they didn't commit.
There's innocent people who are going to die in prison.
I can't get back the time that they took from me.
And I was just left wondering, what the hell is happening?
I knew my life was over right there. That's when my life ended.
They're changing the story that I told them to match to what really happened.
I was just incarcerated for 37 years for somebody else's crime.
happened to me could easily happen to anybody.
Real Life Wrongs is produced by Kelly Fanson, edited by Alex Glutch, promotional materials by Jamie Norrie.